Hey guys, so we've now got the notice of settlement and joint stipulation. You're not going to be happy. I'm not happy actually. Normally I'm singing the praises of Wayfarer and the legal counsel, but on this one I don't know what they're thinking. I'm sure there'll be a plan, but I don't know what it is, so therefore I can't make sense of it and explain it. So let's go through this. Pursuant to the settlement agreement and through their undersigned counsel, Blake Lively on the one hand and Wayfarer Studios, it ends with Movie and Justin Baldoni, Jamie Heath, Steve Sauritz, Tag, Melissa Nathan, and Jennifer Abel. On the other hand, the Wayfarer parties collectively hereby stipulate and agree as follows with respect to the above captioned action. So that'll be both the Lively action, which is this one that has just settled, and the Wayfarer action, which is Wayfarer's complaint that was dismissed. So here's what they've agreed to. And I'm pissed off, so if you're not, I'm going to be really surprised. 1. The stipulated parties hereby irrevocably waive any appeal of any orders in the consolidated action, including without limitation any appeal by the Wayfarer parties of the order on the motion to dismiss. So they're all saying, right, we're not going to appeal. Then that includes Wayfarer. They're now not appealing their dismissed claim. But here's the stupid bit, and it is stupid. Notwithstanding anything herein to the contrary, the stipulating parties acknowledge and agree that Blake Lively does not release and retains all claims, rights, and remedies in connection with her pending motion for attorney's fees, treble damages, and punitive damages under California Civil Code Section 47.1 in the Wayfarer action. The stipulating parties agree that the stipulating parties agree that the 47.1 motion is not withdrawn and remains pending before this court. The stipulating parties further agree that they hereby irrevocably waive any appeal from the court's determination of the 47.1 motion. The Lively action is dismissed with prejudice as between the stipulating parties pursuant to Federal Rule of Civil Procedure 41A1A2. Okay, so now I would have thought that as part of any agreement with Lively, they would have said, hey, get rid of that motion. Take that off the table. Right? They've not done that. And not only have they not done that, they've agreed that in the event that Judge Lyman awards her all of those fees, they waive the right to appeal it. And then interestingly, as I was just setting up to record this video about that motion, Lively has already filed a supplemental letter regarding the 47.1 fees. Like, it's almost like they had this ready to go. So let's read this. Sorry, I'm quite annoyed. I'm struggling to get my words out today, but I'm really surprised at this because I was convinced that if they have agreed to walk away and shut this down, they had the upper hand, Wayfarer did. So they surely would have stipulated that the 47.1 motion would have been off the table. And I was hoping not just for Wayfarer, but also in the Jed Wallace action as well. Lively would just be like, okay, done, dusted, we all walk away. But nope. So I genuinely can't see what's in it for Wayfarer. I know I've seen news articles saying no money's changed hands. I've seen people sort of speculating, she's paid him 100 million. But to be honest, if she's awarded all those damages, treble damages, attorney's costs and fees and everything, then he'll be handing it straight back and possibly more. So why would you do this? I don't understand this move. And I'll need to think about it. I'm sure, as I always do, I'll go away and probably sleep on it for a night or two, and then I'll be like, light bulb, and have a moment where I'm like, okay, maybe they've done it for that, and I'll come back and I'll share that in a separate video. But right now, I'm shocked, I'm annoyed, I'm actually fuming, really, because I just can't explain it in this moment, and I hate things I can't explain. And when I say I can't explain it, I mean I literally see no benefit to Wayfarer for this at all. It is not what I would have done. If I was the attorney, I would have been like, "No, you get rid of that lady, or we're gonna take our chances in the court." Okay. So this is, Lively's letter, her, supplemental letter on the 47.1 fee motion. Dear Judge Lyman, as the court is aware, plaintiff and consolidated defendant Blake Lively on the one hand and we know who they all are, have executed a settlement agreement resolving nearly all claims pending in the consolidated action as captioned above. As reflected in the notice of settlement and joint stipulation filed earlier today, the parties have fully and finally resolved all claims in the consolidated action except one. The only remaining claim is Ms. Lively's claim for attorney's fees and costs, compensatory damages automatically tripled by statute, and punitive damages under California Civil Code Section 47.1, which the parties have submitted to this court to adjudicate with no right of appeal. Section 47.1 imposes severe and mandatory penalties against any party who files unsuccessful retaliatory defamation actions against sexual harassment and retaliation complainants. Under Section 47.1, any communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination, including retaliation, is privileged, so long as the speaker has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. Section 47.1 was designed to ensure individuals subjected to sexual harassment or retaliation can share their experiences with courts, agencies, the press, and others without fear of suit. I'm just going to highlight this so I can come back to this, because there's a point I probably will want to make to that. The California legislature enacted this privilege to provide a clear, unambiguous pathway to justice for victims of sexual assault, harassment, and discrimination. Specifically, the California legislature intended for Section 47.1 to deter litigation that would otherwise force survivors to defend against a long and expensive retaliatory defamation lawsuit by imposing significant remedies for successful defendants in defamation claims. Moreover, because Section 47.1 protects victims from the litigation itself, these remedies must be available at the earliest stage, typically through a motion to dismiss to protect survivors from a punishing, protracted legal process. And I think that was kind of that was a moot point, really, although she pushed it. Like, she was in her own litigation. She filed her own lawsuit, so it wouldn't, giving her the money at the earliest stage would not have protected her from a, protracted legal process, because, she was in it herself. Consistent with Section 47.1's stated purpose, Ms. Lively respectfully requests that her motion be resolved as promptly as possible. No doubt remains that the Wayfarer Party suit is the prototypical suit that the California legislature intended to short-circuit by enacting Section 47.1. The alleged defamatory statements that formed the basis of the Wayfarer Party's retaliatory lawsuit satisfy all elements of privilege under Section 47.1 for reasons that have already been raised to this court. Thus, as the prevailing defendant, which she technically is, Ms. Lively is entitled not just to attorney's fees and costs, but also to compensatory damages tripled and punitive damages. Okay. Just 1 second. Okay, and before I go further, I am going to just dissect a little bit of that. So let's go back up here. So long as the speaker has or at any time had a reasonable basis to file a complaint of sexual harassment, assault, harassment, or discrimination, whether the complaint is or was filed or not. So there's a couple of things going on here. The The statement, first of all, the joint public statement with that sentence we all did not like. Ms. Lively had a right to have her concerns heard. Okay. I think that may be twisted. I think that may be about to be twisted. And obviously she pulled the plug. I mean, Wayfarer, again, it was only for the purposes of trial. So I'm sure Lively will try, but it cannot be used here to justify anything. But the stipulation that Wayfarer agreed that she had engaged in protected activity for the purpose of the trial, it's going to have Lively fans, if nothing else, sort of like, oh, see, and it did at the time, but this will, throw it all together. But the big thing here is this bit that I've highlighted, right? The actual statute itself. And the question is what is Judge Lyman likely to say on this? Is he likely to say that Lively has or any time had a reasonable basis to believe, to file a complaint of sexual harassment? Did she have a reasonable basis to believe that she had been sexually harassed? And to be honest, he's already answered it in his motion on the summary judgment from the 2nd of April. He has already answered it. Good faith basis. A reasonable jury could conclude that Lively opposed practices that she subjectively believed constituted sexual harassment by complaining about inappropriate behavior. There we go. And then he goes on, by the way, to say the Wayfarer parties have not specifically contested Lively's subjective belief that she was discriminated against. And there is sufficient evidence suggesting that she felt she had been. And then after this order, it was all about, well, she believed that she was. She believed that she was. Because that's enough. That's enough. Going by the language of the California Civil Code statute of section 47.1, that's all she needs. And I think that Lyman will grant this. And I think it makes me sit here and wonder, what's the fucking point? Why have we all done this? Okay, so I am going to continue. Okay. Yes, I've done that and I've done that. Okay, so continue. The parties briefed this issue previously, with said briefing completed as of September 29th, 2025. Those briefs included proposed procedures for determining the damages, attorney's fees, and costs to which Miss Lively is entitled. Because the factual record has developed further since that time up to the eve of trial in Lively v. Wayfarer, Miss Lively respectfully requests leave to file a short supplemental brief of 5 pages or fewer to address any impact of the court's intervening rulings since the 47.1 motion was filed, and to propose procedures for adjudicating the compensatory and punitive damages, attorneys, fees, and costs issues in light of these developments. Ms. Lively respectfully requests that any such brief be submitted by no later than 7 days of the court granting leave. There we go. It was practically ready to go as soon as the stipulation to settle was filed. Honestly, within minutes, this dropped too. And I am fuming. I'm absolutely fizzing about this, because I'm very much a believer that Wayfarer are doing what they think is right for them, right? But I just feel like they're screwed now, right? And it pisses me off because the case was so much in their favor, and a lot of that has actually come from hard work of sleuths as well, the internet sleuths, the content creators. And, we'd all worked together, along with all the attorneys for Wayfarer. We'd all really worked hard, found, the evidence that would have refuted her claims, her allegations, proved that she was an asshole, and people retaliated. People were, it was an organic backlash because people did not like her. And it just really pisses me off because I know a lot of us did not like the order on the motion for summary judgment because of comments like that from the judge. And it gave kind of a hint that, there's a really strong chance he could grant this Section 47.1 motion. But I would have, as part of a settlement, I would not have walked away for less than taking this motion off the table. And I don't know if I'll ever have the answer in my head, like come to an understanding of why Wayfarer made this choice. And I'm sure they have got a reason, but I cannot see it. And I just can't see any benefit to them whatsoever for this. Maybe they just thought, we'll take the hit. But it feels like, why did we all put in that work then? Because we really believed in Wayfarer, all of the Wayfarer parties. Why would they just throw that hard work and that strong belief and just throw it away and cave on this? It's not my case, and I'm not a party in the case, and I know all too well how hard it is. So I'm not having, I'm not like having a go at Wayfarer or their council in any way, shape, or form. I still fully support them, still stand by them 100%. At the end of the day, what have we done all this for? Well, we proved how much of an asshole Lively and Reynolds are. We really did. We uncovered all of that. And the ugly side of Hollywood and its deep, dark, murky inner workings. But I think I'm just disappointed because I feel like I can see what's coming next. And I just wish, a part of me wants them to have just taken it off the table, not even go to trial. Like, this is not about, you should have stuck it out and gone to trial. This was, could have just stood your ground, made her waive this right, or she has to go to trial and, defend the indefensible. And we all knew that she had no case. I feel like they had the leverage and they kind of missed an opportunity here, and I don't know why. I'm gonna go away and think about it. Let me know what you think in the comments, though, guys.